same stuff that they charge me for right now. Same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside his jail, inside the courtroom. Judge Washington looked right at her and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington could have helped me on this. Because they got me charged on. They got me charged, Judge. And so this thing, right, for me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Court does call the case of the people versus Lawrence Buckner.
Joseph McMillan, the people, Your Honor.
All right. Mr. Johnson, you're muted, sir. Go ahead.
May it please the court, Kareem Johnson, defendant on behalf of Mr. Buckner.
All right.
What about that mention of anticipating the plaintiff? We're doing an arraignment?
Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Edward Buckner Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir?
Yes, sir.
And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. Do you understand that? Mr. Buckner, you can sit down while we go through this.
All right, sir. I didn't know. I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction.
Sir, forgive me for my emotional upbringing. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are. Miss-
So there's no video.
You may want to mute that.
So this is my freedom is just snatched from me, and I was understanding that this son is why I came to the children. Y'all just talk to me. See, I told you I got shot in the head, so you're not hearing the wrong thing. Okay? And you said it wrong. Video, but now you tell me no video. That's what I'm not understanding, because the whole basis of my freedom today was Judge Simpson viewing the video, and that's why I need help. Oh, what charge is this? This is the charge of they're supposed to have an April 4th in Judge Washington court? Okay, okay. Uh, Potential. I understand the potential. I just, from the time, I apologize ever since, and I'm a little slow right now. So I apologize to the court ahead of time. Y'all be further ahead of me. Second to original charge. Second to original charge that Ms. Johnson, Ms. Washington want to find out. Yeah, I understand, Judge. I'm sorry, I don't.
Okay, so you understand then the maximum penalties on that charge.
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case.
Thank
As to the formal reading, you waive any further formal reading of the complaint, stand in. All right.
you.
All right. Defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea. Set a probable cause hearing, and Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think
Stay in jail. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
Like, I don't want you to tell the judge to adjourn something. Then I need to be heard on it, and I could find out I did nothing wrong. I need help. And helping me is not leaving me inside Washington County Jail or trying to put me on some type of crazy bond. Like,
Your Honor,
I need help.
okay, Mr. Buckner, Your Honor, based on my client's representations, I still ask that the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, you're saying that for 20 seconds, not.
All right. So in that matter, preliminary examination will be in person. It would be set for April 22nd, 2025, 9 a.m. That is before Judge. Well, all right. Right, but I think that will be before Judge Washington. All right, and on that case, his bond would continue. All right. So on the other matter, I'll set preliminary examination and I hear what the defendant is saying. What date? PCC. I set it for the 17th. Card. Okay, then I'll set it for the 10th. I'll just set it out a week. April 10th, 2025, 9 a.m. on that matter. As to bond in this case.
Allegation here is that my client allegedly had some outbursts
witness. I had a chance to look at what was available on the equipment. There was nothing. I'm looking at weakness. And strong was the outcome. Charge with instruction is witness intimidation. That means that he's trying to prevent this witness from coming to court and testifying, trying to change what this witness has said. All of that goes to whether that witness would be able to appear in future court. Taking the best what we've heard from the prosecution. Saying you've been lying on me. Ms. Evans, my client is not saying he said that, but what the prosecution says that she killed you or something to that effect. She shoots you or kills you. Yeah. Notion is for threatening intimidation is that he has to be doing something to fit this witness, saying, don't come to court, trying to stop this witness. I think even if we hold her based on her, I don't think the prosecution should be able to make out a case that his intent was to try to prevent this witness from showing up, coming to court, intimidating this witness from saying, testifying truthfully. That's the necessary. Because I do not believe that he will successfully get a conviction, I'm asking the court set for my client the personal recognizance bond. And here's the reasons why a personal recognizance bond. You have the ability to have no contact. It has a home in Ypsilanti, 680 box. It's not having anything to do with it. When the witness lives separate, he's self-employed, he raises his dogs to sustain himself. He suffers from numerous bad injuries. I believe the court has already been appraised that he's been shot a lot of times. So he's got health problems that arise with that. Finally, he lives with his autistic niece who he has to take care of. He also has a brother who can help make sure that he returns to all future court dates. It's a responsible individual. They should. I think the charge here is a strong charge. I think it's a charge that even taken in the light most favorable to the prosecution, they will be able to prove that he probably caused that.
Thank you. Response.
Thank you, Your Honor. In this case, as in many things, context is key. This exam was on the first Tuesday. At that time, the victim testified at exam. The defendant pointed a gun and racked it at her while she was working as a security guard. It was after this that the defendant asked to go to a bathroom. While walking out, threatened her in the gallery. She immediately reported this to the victim advocate and his assistant prosecuting attorney. Specifically, this defendant said, "You're lying, a lying fucking bitch, I'm going to get you." This is right after she testified being threatened with a firearm by this defendant. Based upon this defendant's conduct, Your Honor, people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court at exam. The condition of the bond in that case, case number 5-121, I'm sorry, I may have misread that case number, was that he had no contact with the victim, and here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case, that he have no contact with the victim in Hudson, have a no-go order as for residential place of employment. And frankly, Your Honor, it is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during a court proceeding immediately after the testimony of the victim is gravely concerning to people. And to our mind, points to a need to set a significant bond to secure the safety of the public and of the state.
So I can respond, John.
Yes, sir.
Obviously, very clearly, something different in the prosecution that describes it as an angry outburst. It doesn't rise to showing any intentions, anyone, anything, except that angry outburst
They had tried to, charge witness intimidation. It's not that the person already testified, said she was lying, was angry outburst. But we're not going to try to hear it, show the prosecution things that the court takes into consideration is the likelihood of conviction. I think the likelihood of conviction is, as the prosecution says very clearly, I think that's the case at all. And what you have is not angry outburst that's being spun, something based on what they saw in context, an unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper context, you'd agree.
That's right. Making a bond with a separate case, and that's exactly what's going on. They can certainly say you shouldn't have said anything, you shouldn't have an angry outburst. That's a bond violation. That's exactly that. In the context of whether or not they should be charging this case, and with this discretion, if they decide context of whether or not they would likely to get a conviction based on that flimsy information they have there, that's not right. So yes, maybe they can say it's a bond violation. They should be actually bringing a bond violation rather than charging an entire case. They can't complain to me and say, oh, well, we've got a new case based on that.
So there seems to be a misperception because the victim testified at an exam that somehow this conduct was not what the victim. The victim's testimony would be needed at trial. And to make this statement, not only that he accused her of lying, but that he was going to get her. When this same victim has seen this defendant firearm at her and rack her weapons, clearly the intent here was to intimidate the witness in question. So based upon this defendant's conduct, I need a $100,000 bond with no 10% is an appropriate remedy. As an additional condition, Your Honor, should this defendant be able to post gas or GPS tether code conditions as to placement of employment residence to the victim. But very clearly, this defendant
I don't know that I have a name for the.
The name of the victim, Your Honor, is
Anything else?
No. What it works is it's on a motion, they respond, they make a response, and it's supposed to stop.
Well, I can actually run my courtroom any way I want, but that's okay. Thank you for the suggestion. I'm gonna order standard conditions, including no assaultive behavior or any possession of any weapons or anything fashioned to be a weapon. There's to be no possession of any alcohol, recreational marijuana, or any illegal drug. I will order no contact with Amy go to either direct or indirect or through third parties. I will also indicate that there's be no mention of any social media or any use of any type of social media. You're also not to go to that person's residence or employment or place of employment, I should say. What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual is highly problematic and something this court cannot tolerate. Should it be that type of individual in this court's mind does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash sure. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established, but $75,000 on that case. Thank you.
It's possibly from the judge watching it. It's probably the same stuff that they charge me for right now. Same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside his jail, inside the courtroom. Judge Washington looked right at me and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington could have helped me on this. Because they got me charged on. They got me charged, Judge. And so this thing, right, for me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Well, you're charged with intimidating a witness that may have taken place in the courtroom. So.
Okay, and sir, this is the time that I got arrested and you sent me back here, the thing that I was trying to work on you was, I mean, the community of people that was helping me, sir, and I know everything I'm saying because you already made a decision, is that the video inside Judge Washington's courtroom, a Wayne Washington courtroom, was the video that would have proved my innocence. The prosecutor told Judge Washington that I was threatening Amy Hunt. She was giving her testimony on the stand. Was on the stand. Wayne Washington stopped the court immediately and said, "No, he's not. He ain't looked at her. He ain't said to her. He's mumbling things to me, trying to get my attention." This is on camera in Wayne Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
Hey, Mr. Brown, Mr. Brown.
Yes. Thank you.
No, I know, but conditions.